welcome to another edition of Coffee Talk with Immigration Attorney Brian Lerner. I'm sure that a lot of you have heard how immigration is getting more difficult, how regulations are coming out, which are causing increased difficulty in getting petitions approved and so forth. Well, I'd like to talk about another one that has come out, how it might affect you, and how it might make your decision to go forward or not go forward with the particular petition change. Now, normally, when one is put into removal proceedings, they're issued what's called a notice to appear or an NTA. That is like if you're in criminal court and there's a charging document which lists, what they're charging you with, if it's burglary or larceny or whatever, and then you end up going to court based upon that charging document. Well, in immigration court, it's similar. The NTA lists essentially, why you're not a U.S. citizen and, what charges make you inadmissible and on what grounds they're finding you removable. And so the NTA normally was in the discretion of ICE when to serve. Okay, it was an enforcement agency, the enforcement part of immigration, that would issue and serve the NTAs. Well, now there are regulations that for those people who apply for U, T, VAWA, all these types of petitions that deal with domestic abuse, victims of crime, victims of trafficking, that if you lose your case, that USCIS can now begin issuing NTAs. This is big on a couple fronts in that now it turns USCIS into an enforcement agency rather than basically just adjudicating petitions. And it has a chilling effect, or it will most likely have a chilling effect, where people who have good VAWA cases or good trafficking cases or good victim of crime cases will be afraid. They will simply be afraid to apply because they're going to be afraid they're going to be put into removal proceedings. And that is essentially the result of these regulations. So essentially when the administration believes that by doing that they're going to catch a whole bunch more people, that's really not going to be the case. It's just going to cause a whole bunch more people to hide, to not take advantage of what the law allows. The corollary effect to that is that, for example, people who are victims of domestic violence, whereas before they could prepare, submit, and hope the VAWA would be approved and get away from the abuser, now they might stay with the abuser. They will live with the abuse, and there's nothing that they believe they'll be able to do with it. Sometimes now, if somebody's a victim of crime, aggravated assault, or any one of the enumerated crimes that allows U visas, they might just go into hiding as well. They won't report the crime. And because of that, the person who committed the crime will and has a better chance of just getting away scot-free. And by the way, a lot of these people who commit the crimes are U.S. citizens, which the administration doesn't want to acknowledge. So the policy of having USCIS begin issuing NTAs will not have the desired effect. It will have the opposite effect. Now, next comes the issue of whether or not you should actually go forward with the petition. Well, as the law stands now, you're not protected. For example, if you're a victim of crime and you have decided against going and applying for the U visa, you're still deportable. If you have no status, you're still removable. Tomorrow you could be driving a car with a broken light, and next thing you know, you're in removal proceedings. So The way things are these days, where everything's getting more difficult, if you have the ability to prepare, file, and submit something to get relief, you probably ought to do it if it's a decent case. It does make it important that you get someone who knows what they're doing. And unfortunately, I have people who, when they want consults, they'll say, "What form do I use to prepare this?" And they think they spend 10 minutes filling out the form, and voila, they're going to get an approved petition. But if you have someone who knows what they're doing prepare the petitions, and it's a bona fide real case, then you should go forward with it. There's no guarantee of anything in immigration law. Even if you marry a U.S. citizen, you don't know what's going to happen. So, if considering you have two choices, one is to do nothing and hide, and then just be in fear that day after day immigration is going to get you, or get someone who knows what they're doing, make a good petition, put it on the table, and then if it ultimately gets denied, right now it's a little unclear if just the mere denial will result in the issuance of an NTA, or if it allows you to appeal to keep the case alive. And then if you appeal, only after the decision of the appeal might it have the NTA issued. That's a little unclear. But certainly don't just sit and do nothing, because that's almost as dangerous as and more dangerous and risky than preparing a good petition and submitting it. So if you like the video, click like, subscribe, call my office. We'll give you an initial free consultation. More on the coming videos. Thank you.